Yeah.
Good morning. Welcome to Citizen Advocacy Center. Thank you all for coming out this morning on this beautiful rainy day. I really do appreciate you all coming through it. For those of you that do not know about CAC, we're a nonpartisan, nonprofit community legal organization. We are dedicated to building democracy for the 21st century. So that means we focus a lot on state and local accountability, transparency, and access. So we love doing things like civic education to help people access their local government, participate, and make the changes that they want to see in their community. I like to say that we are a teach a man to fish organization because we like to help people help themselves and help their community. My name is Ben Silver. I'm a community lawyer here. And with that, I'm going to get right into the presentation. Today, our presentation is titled Use Your Voice, Freedom of Speech. We're going to be focusing on First Amendment freedom of speech. We're going to go through a lot of the case law that sort of gives you the contours of what you can and can't say, what the government can and can't restrict. We're going to talk a little bit about how to use your voice effectively, though that's also going to be a part of our later presentations later in next month and in January. And we're also going to talk about some sort of hot button issues, hot topics that are going on right now. I'm sure you all can think of a few that have been national news lately. I also want to make sure to thank Illinois Humanities Council for helping make this come to fruition. We are funded, this presentation is funded in part by Illinois Humanities. All right. Our first slide is simply the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting... Oh, welcome.
Sorry,
no problem. For the folks on Facebook, sorry, we have our front door right here, and it's unfortunately the only way into our office. So the First Amendment, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of people peaceably to assemble and to petition the government for redress of grievances. Now, this is going to be an interactive presentation, so I kind of want to open it up to everyone in the room. Do you have any immediate thoughts when you look at the First Amendment? I'll give you a second. I know that's kind of a broad question. And you can see I've got highlighted on there, abridging the freedom of speech, since that is our focus today. But do you notice anything? Yes?
I have a question. When one of the things that's happening in Elmhurst with District 205 is the teachers and things. So the teachers have been given like a gag order about certain things. Is that okay because they're employed?
Yes.
You know what I mean?
That's actually a great question, and we'll get into that a little bit later on. In their employment role, yes. The government acting as an employer is different than the government acting as your government. As your the school telling a student that or a parent that would be another story. But because they're employees, there are restrictions they can put on them. There might be some questions with state and local laws with that, and it's a pretty interesting situation that we might get to talk about a little bit later on. Anything else you guys notice about the First Amendment and what we have highlighted?
Highlighted?
Well, no, or anything
I
else.
was going to say that it says Congress.
Mm-hmm.
It only focuses on Congress.
Yeah, it does only focus on Congress, and for a good part of our history, the Constitution itself was seen, and the Bill of Rights was seen as applying to Congress, to the federal government. However, the Supreme Court, over many decades, incorporated, I think, all but two of the amendments in the Bill of Rights to the states. So the states do have to abide by the First Amendment, as well as most of the other amendments in the Bill of Rights.
So a state can't implement a law different from what the First Amendment states?
The states can actually protect your speech more or your religion more than the First Amendment, but the Constitution and the Bill of Rights lays out the minimum of what they have to do. So they can actually, for any of the amendments, if they want to protect individual rights more, and the federal government hasn't acted to do so, the states may do it.
But it's all subject to interpretation, right?
It is, correct. The whole thing is we have a very, very short Constitution, remarkably short actually, and it's a document that has endured for over 225 years. Did I do my math correctly? Yes. The beauty of it is that it can endure that long, but it does take interpretation by the courts, especially at the federal level in our Supreme Court. What about, so you see a list in there, right? You have two clauses on religion. You have speech, you have the press, right to peaceably assemble, and right to petition. Do you guys see any themes running through those? Yeah.
Probably freedom to think what you want.
Yes. That's a great interpretation of it. Freedom to think what you want. Anything else with those? All right, let's move to the next slide. Why is the First Amendment first? Any thoughts on that one? Leon again.
Actually, I might have my history wrong because I'm not a history major, but I think there were actually amendments proposed before the First Amendment. It was just the first one that was.
Well, there may have been some proposed before it, but they did want to put this one first, at least according to some of the framers. Yeah.
Possibly because they wanted to level the playing field, if that's the right expression, so that it was inclusive.
I think that is a good expression. So Charlotte said level the playing field so that it's inclusive. I think that's a really good thought on it. Anything else about it?
Well, I mean,
No, go ahead.
I mean, that's where you start. If you don't have the freedom to speak,
Mhm.
to express yourself as an individual, be it religion, politics, whatever it is, then you've got nothing. I mean, that should be really the basis of any government, I would think.
That's correct, especially a representative democracy like we have. Oh, we got one more person coming in, I believe. Good morning.
Welcome.
How are you?
Can I sneak in?
Oh, absolutely.
You just have to wait.
We'll install the side door next year. So to your thought, I think that's absolutely right. We're a representative democracy. We're a republic. We rely on the free exchange of ideas. Did I see Susan's hand up as well?
My comment's similar to yours, which is to me it's a really foundational statement, and sort of everything else hangs on that or is built off of that.
That's correct. And I included a quote first by George Washington. If freedom of speech is taken away, then dumb and silent we may be led like sheep to the slaughter. Obviously, arguably our greatest founding father found it very important that this was primary, that we needed the freedom of speech as a primary foundation to the country if we were to protect our democracy and our new republic. I also have a quote by John Milton. The founders relied a lot on Enlightenment thinkers, Milton, Locke. So this quote is, give me the liberty to know, to utter, and to argue freely according to conscience above all liberties. So I think those answers were wonderful, that it is this idea, the free exchange of ideas. And I think it's really important to remember that as we go through here, that they're talking about ideas. Freedom of religion and freedom from the government establishing religion. Both of those are about what you are thinking, how you are able to convey those thoughts. Same with the press, same with the right to petition the government, same with the right to assemble. Is freedom of speech unlimited?
No.
No? Any examples or further thoughts on that? I think we all know that at this point, but is the freedom of speech unlimited in terms of what the government can do to restrict you?
Yes. No, it's not unlimited.
Not unlimited.
Unlimited.
That is correct. Any thoughts on why that is? We have this amendment, Congress shall make no law. How do we have restrictions? Congress shall make no law abridging the freedom of speech. Does anything about that phrase pop out at you that might make that possible? Miriam, I saw your hand up. Did you have?
Well, I was going to say just some speech has lesser value than other speech.
That is true, and I think that as we get into evaluating the restrictions they place on it, that plays a huge role. But as that base point, getting past this, Congress shall make no law abridging freedom of speech. Anything pop out at you in there?
Well, they're saying that they can't make a law that will deliberately do this, but there may be other laws that limit things. So, for example, you can't, incitement to riot is not allowed in freedom of speech, but there are laws that address that.
Mm-hmm.
It's not
So
a
you're
law.
saying the conduct rather than the...
No, what I'm saying is that I think the question you're asking is where in this language is there a loophole
Mhm.
that allows restrictions to exist. So my feeling would be that the loophole exists because it says Congress shall make no law. Well, if there's another law, like
If there's another law
that
that sort of,
Right.
yeah, and that does play a role in the court's thinking, especially with a lot of the examples we'll get into. There are also sort of these core things where it is speech. It's just, speech, and they've addressed it directly, but they've been able to abridge that speech. Miriam, I saw you.
Well, the courts have created the exceptions,
So-
and then
Mhm.
the government can then enact laws according to the court's
Mhm.
decisions.
Do you guys think there's any word in there that they might rely on? Shall?
Kinda, as opposed to the courts, right?
I'll give you a
No,
clue.
the word no.
That's the shortest word in there. It's actually the second shortest word in there that plays a huge role. The freedom of speech. Not Congress shall make no law abridging freedom of speech. The freedom of speech. It was a concept when they framed the Constitution. Freedom of speech. It wasn't an unlimited concept. There were precursors in English law. The founders had a concept in their minds, granted as it evolved from then, of what this freedom of speech entailed. But even when they framed it, there were things that were not allowed under their interpretation of the freedom of speech. So they've focused a lot on this one word in there. Well, they haven't focused so much on the word, but they have used that to say that this is a concept and not just a phrase. It's not just freedom of all speech, it's the freedom of speech. Does that make sense? Kinda?
A little bit.
A little bit.
I think as you get into the early interpretation, you have courts who were either actually around for the founding, justices who were around for the founding, or very close in time to it. So they had this idea that no, this was not supposed to be an unlimited right. And so when they look at this, they can see that they can at least make that argument that this is supposed to be the concept rather than a broader phrase. Restrictions on speech. Do you guys think there is speech that should be restricted? Do you agree with the courts? Do you agree that we should have these restrictions? Yeah?
Yes.
Does anyone think we should have, I don't want to put anyone on the spot, but if anyone does think you should have fully unlimited speech, I think there are pretty good arguments for it. I was actually, I was trying to find a good clip to play of one of my favorite free speech activists, Frank Zappa. And I couldn't find anything appropriate, unfortunately. But his whole argument was words are just words, and that we shouldn't be restricting any words. You can restrict actions, but not words. So, I don't fully agree with him on that, despite my admiration for him and his work. But I do think that that's a powerful argument that's out there. What areas of speech do you think should be restricted? And we'll go through some examples and everything.
Anything that threatens public safety or threatens some other person, and I can't make a threat against you, that's illegal, that's assault. Right.
Or incite somebody else to make that
Right,
threat,
exactly.
to carry through on a threat or something.
How do you think they should decide what a threat is? I mean, if I say, Christian, I'm going to punch you right now, is that a threat? Oh, he's walking away. And we'll get into a little bit of the case law on this too. That's one of the slides in here. But is that a threat, or is that something that the government could restrict right now? Me saying, Christian, I'm so mad at you, I'm going to punch you.
Well, I don't believe you, so I wouldn't consider that a threat. If I
That's
did,
an important point. He doesn't believe me.
I don't think that should be restricted, but the physical act would.
The physical act, absolutely.
Yeah.
What about if I were in his face? What if I were right up in front of him and said, Christian, I'm going to punch you?
I believe at that point.
Yeah.
It can also be used at a later point against you, the way the laws are. I mean, someone could say, well.
Oh, absolutely. If I do go, if Christian gets punched and they don't know who did it, and I said that, probably not going to help my cause.
Another point is, like, right now, the way you're saying it, it's like your demeanor was very, like, obviously your intent behind it was, like, non-motivation. You had zero motivation to actually punch him. But if you were to write that on social media, say, and there's no context for your emotions, in that situation, it might come off as being more threatening.
Yeah, absolutely. The demeanor's big, though I do have a good poker face. So how do you think the court should handle that? Like, we're talking about some really sort of in the moment ideas and people's interpretation as you're standing in front of someone and listening to them. Any thoughts on how the courts can?
Well, this is why we have courts, because they adjudicate that kind of stuff
They do,
based on
yeah.
a set of facts that they're looking at.
Right.
And there can be differences depending on what the facts are.
Mm-hmm. And that's absolutely true, and the courts have to do that, otherwise we wouldn't have any basis for it. On the other hand, the courts are always trying to interpret things in a way that they can be applied by the other branches of government. We can't have everything go to court, though we apparently try to. So any other thoughts on how they can grapple with that? Though I think that is a huge part of it. We'll see that as we go forward.
Well, we can't say the word bomb, say, at the airport without being scrutinized further.
Yeah, absolutely. Absolutely.
So places.
So you think they should look at the places? Yeah. So we're sort of getting into these qualities that they look at in the situation, right? Okay. Let's go
It's not so
on.
much freedom though as it is liability, right? Public safety.
Public
So like,
safety.
for instance,
Well,
years ago when Oprah Winfrey talked about the bad beef and the cow industry and whatever, and that there's nothing horrible about that. I mean, she's not insulting, she's not threatening, but she got, pretty much like...
Well, they sued her for defamation. She won that case, though, I think, right? They sued her for defamation.
Yeah, I think she did win that.
I think she won that case. Yeah, they said that, and we'll get into defamation a little bit later, but I think she did win that. But you're right. You're talking about you have speech, and then they're trying to say there's something more to this, right? Okay. Any other thoughts before we move on to some examples in some different areas? All right. First thing we're going to talk about is expression. So you have speech, me talking here, and then you have expression. Maybe I'm wearing something. Maybe I'm doing something that I'm trying to express a thought, but I'm not saying it. So a seminal case in this, Stromberg v. California. California passed this law banning the burning of red flags. They passed it in, I think, 1919. So we're talking getting towards Red Scare. You had the spread of communism in Europe and Asia, but not so much in the United States yet. But you also had workers organizing, and you had a communist element in the United States. They passed this law banning the flag, and a camp counselor at the summer camp for youth, affiliated with many communist organizations, directed the students to raise the flag, and he saluted it and pledged allegiance to the red workers' flag. He was arrested, and they charged him with violating this California law. What do you think? Is that protected speech, or is California's law valid? Can they restrict him from raising that red flag?
That law maybe should have been challenged.
He did challenge it. Yeah. This went to appeal. So, So to be clear, this went to the Supreme Court in 1931. He raised it. I think actually they said it was 1926. So that gives you an idea of how long it took him to go from being arrested and prosecuted under California law to actually getting to the Supreme Court.
Well, doesn't it,
Good morning.
doesn't that hinge on kind of when sedition became, at one point sedition was illegal,
Right.
and that was
Right.
enforced.
Yeah, and I don't cover sedition too much because you're right, we don't have laws on the books against sedition right now, or at least not directly against them. And it was on the books, the courts supported those laws, but they're now off the books, and the court has said that we won't put people up just for sedition. So what I'm going to point out with the Stromberg case is that this is not directly seditious. There were actually a couple of prongs to this, including some intent. So if you're intending to incite sedition, but they banned the actual act of flying that red flag, even if it was separated from sedition. And that's what the court was looking at. So what do you think? Can you raise a red flag? Well, I guess I kind of gave it away. Now you know you can. But in 1931, can you raise a red flag in support of communism?
Does it make a difference if there were children involved?
It doesn't really make a difference. In certain situations, I suppose it could, but not in this case. All right. Well, we can see what the court had to say. They upheld the second and third clauses of this, so I talked about those other clauses. Those were actually inciting sedition or in support of an effort to overthrow the government. But it invalidated the first. This was the court saying that expression is protected under the First Amendment freedom of speech. So even though it says, shall make no law abridging the freedom of speech, we now have expression in there. That's very important as we get into more cases. We'll talk later a little bit about flag burning. You don't have to say anything to burn a flag, but you're saying a lot, right? Any other thoughts? But yes.
Well, more current notion, what if somebody goes on Facebook and says, I pledge allegiance to ISIS? And ISIS is identified as a terrorist group. We aren't exactly at war with them. There's some kind of technical...
That's actually a great question, and we get into probably whether there is more behind that, whether they're doing anything more than just saying that. Providing support to them, material support to them, is a federal crime, and it's the providing that support. So if you say that and you somehow send money over there, yeah, that's absolutely a crime. If you just say it, probably not going to get to that point. Again, sedition is not. Yeah. Oh, yeah. Yeah. I would not advise doing that. Even if you're just doing it for the sake of freedom of speech, wouldn't advise that.
And then I'm guessing you're going to get to this, but the really powerful example that we're wrestling with now is what if you kneel during a
Oh yeah, yeah. We'll talk about that a little bit, and there are several more elements to that. So that's why I put it for a little bit later, even though I think that's one of the top issues right now, and very much related to the issue at York Community High School. All right, burning a draft card. So this is United States v. O'Brien. O'Brien was at a protest in front of the in front of the courthouse in Boston. He and 4 others burned their draft cards. They were surrounded by a mob. The police escorted him inside the courthouse and promptly arrested him. What do you think? Burning a draft card, is that can they restrict you from burning your draft card? There's a law on the books against it, a federal law that was passed restricting people from burning their draft card, and he violated that law. Was the law constitutional?
I would say it was overturned.
You'd say it was overturned?
Yeah, I would agree.
Anyone on the other side? They upheld the law.
Government property?
They said, oh well, that's a good one too. Government property, and they actually they talked about they can force you to hold. You can definitely force you to hold a card, but no. The Supreme Court says the law was aimed at conduct, not expression. They said that this law, which was aimed directly at burning the draft card, but anyone can burn a draft card. O'Brien argued that this was because that they made the law because people were burning their draft cards in protest. Yeah, I have a little trouble with that one too. I'm kind of in between. I think the idea that you have to hold one, that they can force you to hold it, is probably an okay argument. It has to do with national security. But the idea that you can't burn it, that they can restrict that's a little tougher. But the court starts to get in here to say that we're going to separate out what your expression is from what your conduct is. And laws that are on their face not addressing the expression but addressing the conduct, the government might be able to do, and it's going to be a lower standard. What the court says is the government has to have an important or substantial interest, an important or substantial government interest. That interest cannot be restricting speech itself, and that the law has to be has to restrict just that speech and not more than necessary. Does that make sense?
The speech or the conduct?
Well, the law would have to restrict no more speech than necessary. So if it also said that he couldn't say, F America or something while burning his draft card, then that would go too far. It could say he can't burn his draft card, but the second part is restricting more speech than necessary to meet that interest. Any other thoughts on that, or maybe analogs, other situations you might have with that?
So in theory, the government could ban burning your social security card.
In theory, I think that they would have to say that they have an important interest. The interest here was having someone hold their draft card so that they could be subject to the Selective Service Act, so that they could draft people for
There was a
to go to
record.
war.
Burning the card doesn't get rid of the record of your draft number.
That's true, but in terms of the efficiency of it and the actual administration of the program, the court decided it was an important enough interest that people had to hold their draft card.
Oh, but how does that reconcile with flag burning, which is protected free speech? You know, it seems
Well,
clear that
yeah, absolutely, and we will we'll talk about flag burning a little more later. But I would say, what's the purpose of you holding that flag versus the purpose of you holding that draft card, and what is the government trying to restrict? They're trying to restrict in flag burning. That is purely expressive. You're not, there isn't a conduct there that has a governmental purpose, or a legit, at least an important or substantial one. Whereas with the draft card, you're talking about administering the draft while they're at war.
Okay, I mean, I understand.
It is. This is one of those. This
yeah.
is pretty close to the line, I would say. Any other thoughts on it?
So this law, I imagine it was because he was arrested. It was a criminal offense to burn the draft card.
Correct.
Would it make a difference if it was civil versus criminal in terms of,
No, they don't really look at the the bounds of that, at least under the First Amendment, over whether what the punishment is. But that's a good point, and you might get into some Eighth Amendment issues depending what if they put you in jail for life for that might be a problem.
How literal does that law get? It says prohibited burning of a draft card.
I'm not sure.
Throw it away.
I'm not sure. It was an amendment to the Selective Service Act that they passed in 1965. I am not positive, so I can look that up. And you can look that up. Amendment to the Selective Service Act, 1965. I assume that it also prohibited you from tearing it up or from just throwing it in the trash. Because again, and if it didn't, I imagine that would have been a tougher issue for the court to grapple with. Because if it were just burning it, well, they knew people around the country were burning their draft cards in one specific form of expression. So if they were just saying that, probably a little tougher issue for the court. Threats. So we talked about this a little bit, and we have this case, Watts v. United States. Watts was protesting the war in Vietnam. A lot of this is going to involve Vietnam War protests. I think you're starting to see the theme. The reasons for that are twofold. We had a very strong free speech movement through the 1960s and 1970s, so that's where it starts. The court was also changing. The court was expanding what was allowed. We talked earlier about, just briefly, about how we actually had sedition laws on the books in the first half of the 20th century. We were a lot more restrictive on speech, and it was around this time that the country as a whole and the courts started to move away from that. So Watts says, if they ever make me carry a rifle, the first man I want to get in my sights is LBJ, Lyndon B. Johnson, President of the United States. He motioned like he was aiming a rifle and taking a shot, and the crowd laughed and applauded. What do you think? This was obviously a threat against the president. They arrested him, said it was a threat, said they could prosecute him. He appealed. What do you think the Supreme Court said?
Guilty.
That it was okay? Guilty?
I think
So we're on both sides
he
here.
say guilty, you can't do that, that's threatening.
That's threatening. Miriam, why do you think okay?
Because he said if.
If.
And
Yes. If.
If.
If's big, right? He's not saying he will shoot him. He's saying if. And he's also not standing there with a rifle or anything. He's just motioning, right? The government argued that the crowd was kind of prodding him on and that he was prodding the crowd on. But the Supreme Court says, taken in context and regarding the expressly conditional nature of the statement and the reaction of the listeners, we do not see how it could be interpreted as a threat. Yes, Christian.
So using this precedent, I think it was Madonna and women's rights on Washington that said she wanted to bomb the White House or something like that.
She was, man, that was really recently, and I thought she came pretty close to. I think the reason she may have gotten away with that is no one expected Madonna to bomb the White House. If an individual said that, I think her celebrity somehow probably went into their interpretation of how she was, was saying that. Yeah, that's a tough one. And you can see all the time, you hear about someone making a threat on Facebook and the FBI is knocking on their door 10 minutes later.
Yeah.
They're very serious about threats to the president. I think that the public nature of his speech also played into it. Ted Nugent, on the other side of things, said some pretty inflammatory things regarding the health and safety of President Obama, and he was never prosecuted or anything for that. So you really do have these examples of celebrities on both sides very publicly, and I don't think there's much case law on that public nature of it, but I do think that's going to play into a court's interpretation of if you're actually making a threat. Like, I'm making a threat in front of 1,000 people, really, so that someone can stop me and so that everyone knows what I'm going to do and everyone's going to know I'm guilty. Maybe not a true threat, right?
But that plays into a scenario where a public figure might make a statement like Madonna would somehow encourage everyday people to
Incitement.
do the same thing, but it's not okay for them to do it.
Yeah, and we'll, I don't know if it's next slide or a couple on, we've got a slide on incitement, and that's a big one, because you're right, you can encourage other people to do it, and that might be restricted. Any other thoughts before we move on from this one?
All right. Yeah, I have
Yeah. Yes.
Like you said, social media threats. Are those taken seriously?
Sure, depending on the case, though.
Because anybody could just yada yada yada.
Yeah. I mean that's absolutely true. Again, they're going to look at. They're starting to look at the intent behind it. Were you trying to make a threat, and is it going to be interpreted as a threat on the other end? Mm-hmm. So depending what it is, again, if it's one of these if statements, if it's completely outrageous, they might not interpret it that way. But especially if it's against the president or against a federal lawmaker, they're going to investigate, and they certainly have the authority and prerogative to investigate.
And there was a case in the Fifth Circuit, Texas, Louisiana area.
I was about to bring that up.
A student or a teenager, I think, anyhow, posted rap lyrics, and it was about bombing the school, or shooting up at a school.
Mm-hmm.
And so he sued. They I don't know, suspended him or expelled him, and he sued. And at the appellate level, the court said that the threat was
real.
They considered it serious.
Yeah.
And then the Supreme Court did not take the case.
Yeah, and I think that's a really important one. And there's one on the other side where a gentleman who, well, I use gentleman loosely, had written on Facebook, if you wanted to kill my ex-wife, this is where she would be at such and such time. And he wrote it in the context of like it was in a story or something, like he was writing a story. And the court said it was fine. I think again that was the circuit, so we do see a split there. So they're struggling with the online threats. I think in a lot of contexts, we're seeing the courts try to grapple with media, with social media especially, and online. I can't give you a good answer about where you're going to cross the line from that if to where they're going to take it seriously. The case law starts to paint the picture, but a lot of the conduct that you're going to see is right in that in-between area. One more on threats. Virginia v. Black. The Ku Klux Klan burned a cross. They had a law in Virginia that specifically outlawed burning crosses. All the context and history behind the Ku Klux Klan was there. This was a 2003 case, so fairly recently. What do you think?
If it's a cross that's burned in a field, not associated with someone's house, then
let me just, for the purposes of this is a different case that I'm going to mix in. What if they did burn it in on someone's lawn, and they were being prosecuted not for the destruction of property or the safety, but for that actual expression on someone's lawn? The law said no burning crosses generally, but what do you think?
That's a direct threat.
Yeah.
Burning a cross?
On someo's lawn?
I'm not getting it.
So,
I think it's totally fine to burn a cross.
I want to point out I erred in not reading this portion of the statute. They said it would be prima facie evidence of intent to intimidate. You think it's valid? Court said no. The presumption of intent, so saying that that will be prima facie evidence of your intent to intimidate, that's putting the burden on the accused. So they actually went to the 14th Amendment, and they said that this is violating your due process and equal protection by saying, by shifting that burden through the law. That is an essential element of this crime, the intent to intimidate. That you can't give someone intent just through that action. They would have to show that. So if they burn that cross while saying, I'm going to kill you, well, there's the intent, right? But without that actual intent, the law cannot just make that.
It can't be implied.
Can't be implied.
How does that square? Wasn't there a case in New York where they banned the wearing of the
mask,
the Ku Klux Klan hoods, or?
No, they allowed them to wear the hoods. They allowed them to wear the sheet. They did not allow them to wear the mask.
Oh, right.
They looked at that. They said the expressive content of that was essentially duplicated by the. So there was that aspect. I personally, I had trouble with that case. I'm a fan of anonymous speech being allowed, even if I generally wouldn't participate in anonymous speech. That was a really tough case, and it was the Second Circuit, I think, with Justice Sotomayor actually sitting on the Second Circuit at the time. That is a tough case, but what they were looking at there was again the conduct, because covering the face, they had a public safety aspect of it. So certainly they could say, well, you can't burn a cross or burn anything, in a forest or in someone's yard. Fire laws, right? Any other thoughts on that? That's a really tough one, right? I mean, I think most people oppose cross burning with its historic legacy. It's really tough for us to we probably, a lot of people feel they want to block that. Christian?
If cross burning was made legal, I think that would make a slippery slope in the context of cross burning, not as a threat, but maybe for artistic expression, like if you're making a music video satirizing the Ku Klux Klan, or something of that nature.
Yeah, so if they say it's prima facie intent to intimidate, well, if you're doing it, very clearly, I'm not very cultured. I can't think of any famous artists who might do it, but send an artist out there in the field and doing it and very clearly filming it as art. You're right. If that law stood, it would still be intent to intimidate, even though the artist's intent clearly is not that. Right. Very good point. Fighting words. I don't know if we talked about this yet. It's related to threats, right? Czaplinski v. New Hampshire. This is a really interesting case. Czaplinski was a Jehovah's Witness. And he was out proselytizing in the town square, the city square, handing out pamphlets. He was saying that organized religion is a racket. It's racketeering. And a police officer came up, and there was some back and forth, and he called him, the record says he called him a goddamned fascist and damned racketeer. He did not admit to the goddamned, he admitted to damned. He said, yeah, I'm a Jehovah's Witness. I didn't say that. The court prosecuted him under a fighting law, said it was fighting words, him saying that to the police officer's face. What do you think? Are those fighting words that could be banned by New Hampshire law?
No.
No?
No.
In that particular case, yes.
In that particular case, yes.
But not
so Miriam knows the case. Anyone else? Did anyone else think yes without knowing the case? No? A lot of no's. It is a yes. Fighting words are those which by their very utterance inflict injury or tend to incite an immediate breach of the peace. I don't know. How do you interpret that?
Well, that's like what you said earlier. I'm going to punch you in the face.
Yeah.
That's the same thing.
They've talked in other contexts about, being someone's face and insulting their mother or something like that.
Yeah.
I don't know. I don't know where you draw the line. What if it's their stepmother? I'm really not sure. And the court went on that fighting words are of such slight social value as a step to truth that any benefit that may be derived from them is clearly outweighed by the social interest in order and morality. So that's really interesting. We talked about the First Amendment being this ideas, right?
It's not because he was a police officer. It could have been anybody.
Could have been anybody.
Okay.
Correct.
But this case, I mean, this is.
I'll get to that. The facts of this are really fun. Yeah. But before we do so, this is really interesting, right? Fighting words. There isn't much case law recently, but this is still valid law.
But if you take it into context, 1942.
Yeah.
Our society has changed.
It has changed. So
and
maybe today
continues to evolve
exactly.
Today, right?
Fighting words might be different today, or maybe the court's going to change it. The court has, in the arena of freedom of speech, they have turned on a dime occasionally. Things like sedition laws, they changed almost overnight.
Isn't again open interpretation, inflict injury?
Yeah.
What
Yeah.
Type of injury? Emotional injury, physical injury?
They're talking physical injury there. They're definitely talking physical. But I suppose if it were an emotional injury that were very likely to make me just punch you, then they might be talking emotional injury.
How is this saying damned fascist and damned racketeer? How is that inflicting injury?
It was 1942.
Yeah, it's hard to conceptualize, right?
So I'm sorry, I was reading that wrong. You're correct. That is emotional, but it's an emotional injury that's likely to and the cop did not. The cop just arrested him. He didn't beat him in that case. The crowd kind of beat him. They were actually they formed a mob. So here are the other facts. The cops had already been there. They told him that he should probably leave. It wasn't very safe for him as this mob was forming around him and starting to push him and try to steal the pamphlets, as he called them, racketeers for being organized in organized religions. Well, the cop came back and said, didn't try to disperse the crowd, said, all right, I'm going to take you in. And that's when he called him a damn fascist and a damn racketeer. I think I can understand the sentiment, but, that was, did his religion at the time have something to do with it? Yeah, probably. He was not treated very fairly. Did you have any more facts on this, Miriam? I know you, but that's what you knew about it, right? Was that this was very much the mob was, yeah. A lot of these.
The mob was already there, so he didn't even incite the mob.
No. Yeah, they were just there, and it wasn't like he was telling them to do this. He was just preaching his religion, and they reacted that way to it.
Probably because law enforcement was involved. Also, it turned that way.
Any sort of modern examples that you think of where this could be relevant, Christian?
Well, I just saw the other day in Texas, on the back of somebody's truck, they had this decal that said Donald Trump and FDR too.
Yeah, that was a fun little article they had. Yeah, that one was interesting. So this was in Texas, a big truck with a big F Donald Trump and F you too if you voted for him. And a sheriff posted this on Facebook and said, if you know whose truck this is, I want to bring him in for questioning. He apparently had gotten word from an assistant, or from a prosecutor in the district attorney's office, but not the district attorney, that she would be willing to file charges for this. And so he was going forward with that. The district attorney ended up jumping in, and other people from his office were like, no way. No way. You can absolutely say that. The fact that she was driving around with it for all that time and, hadn't been, shot at, run off the road, anything like that, is probably a pretty good indication that it was not fighting words and that it was protected speech. They did end up arresting her. She had a warrant out for fraud. You gotta be careful. That may have been, the indication was that someone reported her for that, probably because they were upset with her over this and now they knew where she was. But you know what? If you got warrants out, you probably should
stay low.
So, I have a question. So,
But I want that sticker.
are you saying the line that is supposed to be, you're not supposed to be crossing, is like the vulgar language, vulgar language and profanity versus like.
And we'll get into that a little bit more.
Fighting
Yeah.
words.
Well, fighting words, it's got to be. There's not a great standard. If I got in your face and called you something really offensive and called your mother that offensive thing too,
right.
It's the idea that a lot of people are going to just haul off and punch you without even thinking about it. It's kind of that immediate thing. They're not going to think about it. They're not going to think through their actions. It is just going to promote this immediate response to punch someone or push them or kick them or whatever. Pull out a gun. I mean, It's 2017, right? It's in the past, maybe it would have been something that would have provoked a duel. Got a little bit of that in our history, I guess. Incitement. So we started to talk about this a little bit. We're back to the KKK. So that's the other one we have, right? Vietnam War and the KKK. A lot of our free speech is going to come from those two places. This was a Klan rally in Ohio. mid-60s, and they talked about, the speakers there argued for revengeance against blacks and Jews in some
So the
more
fact that-
colorful
The fact that
terms.
it's not a word didn't disqualify.
Right? Right? No, it didn't. They I don't know if it was just, a colloquialism that was in use. They had some interpretation around it being sort of an active, I don't even know. You see the word revenge related to that, so an active sort of aggression against them. And Ohio prohibited advocacy of crimes, violence, and terrorism as a means to a political end. So trying to get blacks and Jews out of the country or something would be their political end, and they are here arguably advocating for a crime potentially, right? And revengeance. I don't know what crime revengeance would be, but we can get creative. What do you think? Is that law valid?
I wouldn't think so.
Christian?
Would revengeance, whatever that word means, be subject to interpretation?
I mean,
so it might not.
Was it intent to harm inherent of that
well,
word?
I think that the speaker didn't have any intent to harm at least himself. He wasn't saying, I'm going to go and kill these people. But he's saying revengeance. Maybe other people should.
Is there any legal way to get revenge on somebody that could be reasonably?
It was pretty clear that he meant, a physical action, pushing them out, intimidating, things like that.
Well, that
terrorism.
makes a big difference, yes.
Yeah. What do you think? So.
Yeah, I think that it's clearly, even if you don't know what the word revengeance means, it clearly has a violent element.
It does, yeah. That's a violent element. I think that's a good way to describe it. Yeah. So do you think it's valid or no?
I think that they could be prohibited from saying that because it seems to me an incitement to violence.
Okay. Supreme Court. The constitutional guarantees of free speech and free press do not permit a state to forbid or prescribe advocacy of the use of force or of law violation except where such advocacy is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. Well, that's really interesting, right? This is stricter than some of the other earlier stuff we saw on threats and everything, and it's certainly an advancement in that direction. They were at a rally. They weren't, across from a community center with Jews and blacks inside, where people are going to go across the street and start killing people. So maybe that gets to that imminent aspect of it. What do you guys think? Right again, it's the KKK, and I could see the instinct in the room was to prescribe this activity. It's tough to grapple with a little bit. Yeah.
Would this a modern day example be like the Charlottesville rallies?
Charlottesville rally, yeah, that's probably a good example of it.
Where they said Jews will not replace us.
Yeah, yeah. Something. I'd say this was probably even a little bit more violent than that in the speech itself. Certainly, the actions in Charlottesville could be seen as very intimidating, and they were actually, they were in close proximity to the other folks. They were right in the city, but that was protected speech. There were some limitations on it.
It's like freedom of expression.
Yeah.
So.
Well, with the Brandenburg case, we see this test come to light. For incitement, you have to have intent. So you have to actually intend to get the crowd to incitement. Imminence, it's got to be close in time, and likelihood to actually happen. So again, the fact that the rally didn't immediately take off and go after someone. So that's going to be one of the things we see with incitement. Where it actually does incite something, a lot more likely to have prosecution for incitement.
So had they said in that rally, we're all going to meet at a certain date at a certain time?
Yeah, that certainly could be. That's also, you're going to get into criminal conspiracy with that, because then again, you're talking about the actual action and planning of a crime. Okay. Vulgarity. This is fun, right? Cohenview, California. This is where my Frank Zappa songs and quotes would be lovely, but a little inappropriate. So Cohen wore a jacket reading F the draft into a courthouse. He was arrested for law against disturbing the peace. What do you think?
There's no fighting words, though.
No fighting. Well, so this is, we're not talking fighting words here. This is going to be a different area. Though they did get a little bit into the fighting words, if they could provoke, someone to into fighting action.
Right.
But this is prescribing vulgarity itself. So, your 4-letter words. Christian.
Well, I'm not sure I agree with like the criminal aspect of it, him being arrested. But could the fact that it's a courthouse, it's in a government building?
Yeah,
There's
that's
a certain level of decorum expected?
certainly that could be part of it. In this case, that wasn't. And to your point, and maybe I should have mentioned this a little bit at the beginning, but time, place, and manner. The government has a lot more leeway to prescribe the time, place, and manner of speech. So you're right. If I go into a courthouse, they can say, no, you can say that outside on the public square, that classic public forum, but you can't say it in the courthouse because we're not just generally open to the public. We're not an open public forum historically. This is a place where we go to try cases. So you're right. But this law was much broader than that. It was disturbing the peace. He could have been arrested for wearing that outside under this law. Any other thoughts on it?
Well, wasn't there a recent example of this where a woman went to Congress with held up a sign?
Yeah. Well, Congress, and again, that's not an open forum. And she was arrested for laughing, actually, because they said she was disorderly. They finally dropped that prosecution recently, so that might tell you a little bit. But certainly disrupting Congress, you can be arrested for that. That's disrupting, though. So what do you think, though? Vulgarity, just that word, is that something that they can prescribe?
I'd say no.
No?
And
We talked about it a little bit already, right?
yeah,
The truck?
and then the word has value in expression about
Yeah.
how the person feels about the draft.
This is one of my favorite quotes. Justice Harlan writing for the majority. For, while the particular 4-letter word being litigated here is perhaps more distasteful than most others of its genre, it is nevertheless often true that one man's vulgarity is another's lyric. The funny thing is, this is 1971, and there was a lot less of that in popular music and culture. But I guess that was a little prescient, right? Knew what was to come. But no, I love that quote, and I think this is one I won't stay neutral on at all. I totally agree with that. Any other thoughts on it? Yeah.
I was just doubling back to the Texas.
Yeah.
F Trump, that's vulgarity, but it is, if it said kill Trump.
Yeah, then you might have another problem. Threat, that's again getting into threats and incitement against the president. Might depend on the context.
In more ways.
All right.
If I can just cite a little more notes. So I was just going to my Facebook to find it because I saw it a few days ago. So there's this F Trump bumper sticker.
Yeah.
And then my friend posted, who's Jewish, posted a car sticker, on another car. It's all over Facebook, and on that car sticker it says "Proud Anti-Semite." Is that how you say it? Mm-hmm.
We'll get to hate speech a little bit later. I don't even think that would rise to the level of hate speech saying they're in that rather than, they can do that under that standard as well. I don't know who would want to advertise that, but that's, so. Following vulgarity, we'll go to another one, obscenity. So Miller v. California, you have the owner and operator of a mail-order pornography company. It sends videos and I think they said books and other things through the mail. He sent out essentially a solicitation. I guess it had some provocative content in it, and he sent it all around, and it went to this restaurant. 5 copies went to the restaurant for some reason. The owner and his mother, anyway, reported to the police, and he was prosecuted under California law.
About they had to cover up the images while it was going through the mail.
There might have been, but that's sort of and that gets into limiting but not restricting and time, place, manner a little bit, right? Talking about. So here's what the court said: the Miller test. This is what we look at. So obscenity, you can ban certain things as being obscene, child pornography, things that are just. We'll go through the test. This is a quote from the case. This is a 3-part test. They were very clear about this, that this was going to be the test going forward. whether the average person applying contemporary of minors and everything, but I mean, are there things with consenting adults that could be banned? Non-consenting adults? Yeah. So.
Wasn't this in New York? There's a show on TV now about
Different one.
New York and
Different one.
pornography. And
Different one. There have been a bunch.
And the Maggie Gyllenhaal in the commercial says, "Oh, we're allowed to do this because apparently New York doesn't have any community standards." Look, and I thought she was referring to this case.
Yeah, I mean, community standards might play a role into it, right? Because you're talking about the average person, so. Well, yeah, and I mean, that probably gets into the standards of what an average person would think. Again, whether the work depicts or describes in a patently offensive way sexual conduct specifically defined by the applicable state law. So the state would really have to prohibit it by detail. I think that's part of it. I think also the idea that it is on the internet and that there are more ways to restrict that content. It's more on a private platform. The internet itself is public domain, but the sites that it may be on might not be. So I think there's that aspect to it. But yeah, I think that is a tough thing to reconcile. And part of it is just that our culture in more recent years has not led politicians to write very restrictive laws on it. I think if we had some more restrictive laws and the court had to interpret it again, they lean pretty heavily on the originalist arguments, trying to reconcile with that. Speech is one of those. It's such an expansive thing that they really haven't been able to just to stick to, what the standards were in 1789. Flag burning. Okay, I just started bringing it up. Texas v. Johnson. Johnson doused an American flag in kerosene and lit it on fire right outside the Republican National Convention in Dallas, I believe it was. What do you think? Legal? Describe particular conduct because it has expressive elements. So again, they're looking at, is this law designed to go to conduct on a neutral basis, or is it going to expressive conduct because of that expression? The court also said the government may not prohibit the verbal or nonverbal expression of an idea that a false statement. Do you think that's illegal? Do you think the courts can, the government can stop you from doing that? They can make it a crime?
If there's damages.
Well, if there's damage. Well, not for the criminal defamation, I guess you wouldn't really have to have. Because civil, you'd have to have damages to. But damage to the reputation? Yeah, absolutely. I saw Christian and.
Oh, well, I was thinking, the way I'd like to think about it is they can take action after the defamation, but I don't like the preemptive, like you can't say that because it's defamation.
Oh, so prior restraint?
Yeah.
Yeah, that's a good point. Laws on prior restraint are yeah. No way, it would just stifle conversation.
Where do they draw the line with public official? So, for example, elected.
Yeah,
for sure,
yeah,
but
that's a little tougher.
A state trooper, that's someone who's just got a job. It happens to be a government job.
Well, in that case, I think he was an elected official. I think he was a sheriff or something. But yeah, that is a little tougher. We'd have to really get into the case law, and this is a crash course through the First Amendment in 90 minutes. So, hate speech. We talked about this a little bit earlier, and this is a really interesting recent case. Federal law prohibits trademarking of names that disparage people or beliefs. Mattel v. Tam is this case. The front man of a band called the Slants tried to trademark the name. He is Asian American. The band is large, I think all Asian American. So they were making fun of themselves, but they were using this derogatory phrase to describe themselves. And the Lanham Act, which involves trademark law, prescribed that trademarking of phrases like that. Went up to the Supreme Court just this year. What do you think the Supreme Court said? Can they prohibit the trademark based on that hate speech being part of it?
No.
No?
They didn't.
Well, okay. They didn't. Yeah, no, they didn't. So Justice Alito, for a unanimous court, Gorsuch was on the court but hadn't heard the case, so he did not. So 8-0 court. Speech that demeans on the basis of race, ethnicity, gender, religion, age, disability, or any other similar ground is hateful. But the proudest boast of our free speech jurisprudence is that we protect the freedom to express the thought that we hate. I think that's really important. We got to it with that last quote. Our freedom of speech has evolved into this where we sort of take pride in the fact that we allow that speech. Yeah.
Was it a baseball game recently where someone in the dugout?
Yeah, did the same thing.
What happened to that guy?
Well, he didn't get suspended. I think he maybe should have been, but that's a private situation. We'll get into that a little bit.
What did he do in the stands?
He essentially the same thing as the hate speech at an Asian pitcher. Yeah, Christian.
Well, the fact that it's an all-Asian band is interesting, I think, because that's like reclaiming a term, right? If you want to say that's offensive, then what about the NWA? You have to get rid of that name too.
Yeah, that's true. That's true. I mean, I think the point though would be that even if someone meant it as an offense, it would be if they'd be able to trademark it. Yeah.
So I'm confused. What was the ruling that this was saying that this hate speech trademark was allowed?
Yeah, because the trademark law specifically said that you could not trademark hate speech as that specific content of expression. So it's aimed directly at the content of that expression. Christian.
Does this have any implications for the Washington Redskins?
Yeah, it could. That was the big thing with this, and I think the hope of a lot of people opposing the Redskins name was that this would go the other way, because then all those Redskins trademarks could be invalidated. Yeah.
There are in last year, 2016, there were over 6,000 cases filed for hate speech.
Yeah.
The majority of them were against African Americans. Someone filed
right.
against the African Americans. But
those weren't for hate speech; those were for hate crimes. Because hate speech, that's. I don't want to get too much into it, especially because we're running towards the end. But when that speech is combined with a crime to show that the motivation behind that crime was hate, if I punch you, if I kill you, because of one of those protected qualities, that can be a hate crime. The speech itself there is not what's being prescribed; it's the conduct and the intent behind that conduct. Speech in schools. We're gonna run through this because we got about 10 minutes. Tinker v. Des Moines, seminal case. This was, I didn't put the year on there, but this was decided in 1969, I believe. No, actually it was later than that. It was in the early 70s because it was a long case. Mary Beth Tinker, her brothers and a friend decided to wear black armbands to protest the war. Principals at their two schools got wind of this. They said, no way, you can't wear an armband. What do you think? Can they stop someone from wearing that armband to protest the war?
Yes, you can.
No, they can't.
No.
Cannot.
I was about to say.
It can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. They have pulled back from that a little bit over the years, and we'll talk about that a little bit. What they said is that because the principals, there was no indication that this was going to disrupt the school day when the principals did this. It was more that they, the sort of support, patriotism and everything else, they banned it. So what the court said was that restrictions only for speech that will materially and substantially interfere with the requirements of appropriate discipline in the operation of the school. Yes, they can make restrictions only for speech that will do that. So they have to show that this is going to materially or substantially interrupt the day. There might be things that on their face, wearing them to school is going to do that, but generally they're going to have to provide some basis for that. Maybe it was a disruption in another school, or maybe it was a disruption when someone did it outside the school, they can say students can't do that.
But
Yeah.
question. So I served for several years on a school board.
Yeah.
And we routinely prohibited
Yep.
certain types of
Yep.
things from being worn. And our attorneys always said, yeah, that's okay.
Yeah.
we do that.
A lot of that is going to be is not going to go to the content of the speech. It's going to go, things like dress codes for how much skin is showing or something like that, or
Yeah,
for
but
gang
we-
symbols,
Or like
things like
gang
that.
symbols.
But we even did things like, certain content on it. Sure,
Mostly,
offensive
there's going to
words,
be
things like that.
mostly it's going to be that there's a record showing that that's going to be disruptive to the school day, because if they get past that, if it's not going to be a disruption, if it's not like a safety thing, but they've pulled back from the Tinker standard a little bit too, and I think we'll get to that in the next case a little bit more at least. Student newspapers. So Hazelwood v. Kohlmeyer, seminal case on this. I'm not going to get into the Illinois law, but we have actually put student journalists essentially their full constitutional rights. So this case does not apply so much in Illinois right now. But a paper included an article on teen pregnancy. They had interviews with 3 anonymous students who had been pregnant. The principal was worried that those students would still be identifiable. He was also worried about some of the sexual conduct described, as well as birth control. And he decided to censor the paper. Can he do that?
No.
No?
Yeah.
Yes?
Yeah, because it's part of this. It's technically part of the school.
Part of the school.
Yeah.
Schools can regulate speech that reasonably appears to bear the imprimatur of the school, as long as the school also has a legitimate pedagogical concern. So this is students in this paper class, right, in this newspaper class, or in the extracurricular. They're trying to learn to be good journalists, and not only that, but this paper, it's going to say Hazelwood High School across the top. So looks like it could be the school speech, and there's this pedagogical concern in terms of teaching them the journalism standards and worry about the students in the classroom. So what themes are we seeing from the cases here? I want to do a quick recap. We're running close on time. So content neutral restrictions, right? The ones that are looking at conduct but might pick up some speech. You have to have an important or substantial governmental interest. No more speech is restricted than necessary. And then the other thing that you get through the case law is that they have ample alternative channels. So, some of these things they might restrict, for instance, burning that draft card. There are other ways to say that, right? There are other ways to express that exact sentiment. That's this similar thing. Miriam brought up the KKK case in the Second Circuit. They were allowed to wear their robes. They were allowed to wear their hoods, but not their masks. The court said the fact that they can wear those other things, it's really just repeating the same speech out. Everyone knows then that they are the KKK and that this is what they are doing, this is what their message is. Restrictions on content. So when you're going directly to the content of the speech. So that can be things like fighting words. It can be things like vulgarity or obscenity, depending on the case. They have to have a compelling governmental interest. Narrowly, the restriction has to be narrowly tailored, and it has to be the least restrictive means of meeting that interest. This is called strict scrutiny. The sort of colloquial thing the lawyers will say that strict scrutiny is strict and it's actually fatal in reality. Not exactly true. They do uphold some laws under that clearly, but generally, if you get into a court and they're applying strict scrutiny, the government's not in very good shape. It's very difficult to survive strict scrutiny, which is why the more content-based restrictions are sort of limited to these historical bounds, things like incitement, fighting words. Compelled speech, we're going to briefly cover. Tax returns, compelled to do them. Again, that's conduct. What about cigarette warning labels? Can they compel tobacco companies to put those warning labels on there? Yes. Well, they're on there, right? Yes. Well, a few years ago, I think it was 2011, they had some cases on this. The Surgeon General wanted to put some very graphic images of cancer patients on there. Guy with, what do they call it? With the trach. Yeah, trach. What do you think? Can they force the companies to put that on there?
No. Not in the U.S.
Yeah, they couldn't force them to do that, but they can. So there was some. The courts, the circuits looked at those and said, yeah, they can put the warning on there with that health interest. Part of the reason this is commercial speech. For commercial speech, there's slightly less value placed on it. Again, it's the idea of exchange of ideas. Commercial speech, the courts have interpreted not to be sort of in that marketplace. Pledge of Allegiance, we talked about this a little bit. Students, I forget if they were Jehovah's Witnesses in West Virginia. They did not stand for the pledge, and they were reprimanded, and they were suspended. What do you think? No? Can't kick them out?
Can't kick 'em
Yeah,
out.
I think we've been over that. That's correct. Again, I think this is really important to look at, especially as we get to the kneeling issue in football. Granted, it's the teams doing that, but the idea that you have government entities and elected officials trying to force people to do that. You're not just talking about their freedom of speech. It's not just that they're expressing. It's that you're trying to compel them to express something else, right? Very, very restrictive when the government can compel speech. Something like a tax return, it's conduct. Something like the tobacco company, it's commercial, and it's this very specific thing, this very specific health thing. What about license plate motto? Can they force you to have a motto on your license plate, state motto? I mean, we've got, what do we have, Land of Lincoln on ours? Can they force you?
Yeah. Well, if you're gonna drive and own a car in the state, and that's the state license plate, what can you do?
But can't it just be a car with
It depends on the
numbers
motto.
on it?
Can't force you to do it. Can't force you to do it.
So what would you do?
I've tabled.
They have other plates. They have some, without mottos on it.
Actually, and also in Orland Park, not too long ago, this past year, the city sticker they wanted to, or the village sticker for the vehicles, they wanted to put Blue Lives Matter on
Yeah,
the sticker.
yeah.
So we got a
Yep.
call at the office, like,
Can't
is
do
that
that.
legit? And it's like, well, that's compelled speech by the government.
Yeah.
So it's not a smart
Yeah.
move by the government.
And the point is, going back to, it's going to be strict scrutiny. They're forcing you, not only is it content of speech, but they're forcing you to do it. They're going to have to meet strict scrutiny. They got to have a compelling interest to put that motto on there. It has to be the least restrictive means of doing so, of getting that message out there. There's no way they're going to reach that standard. So use your voice. We're going to this is sort of a preview of where we're going to get to, especially with our next session on the Open Meetings Act. What do you need to know to use your voice? You need those time, place, and manner restrictions, so when and where you're speaking. You can go out to that public square and talk, but you can't always just go into a school and start, spouting your message. You might be able to speak your message on the street, but you might not be able to scream your manifesto through a bullhorn at 2 a.m. I've been there. It did not turn out well. You also need to know if your speech is otherwise restricted. Are you bordering on those fighting words, incitement, anything that is restricted? Typically, you won't be, but if your message is particularly provocative, you got to have an idea of what that law is. The other thing we're going to especially get into next time is crafting your message to your audience and circumstance. In terms of the Open Meetings Act, we're going to be talking about going to public meetings, who you're trying to address, who you're trying to convince, what the situation is. All important to think about as you use your freedom of speech in the public context. Yes, the government can't restrict you beyond what we talked about today, but it doesn't mean it's the best way to get your message across. Some hot button issues which we started to talk about, and I know we're about out of time here. I just want to jump forward to campaign finance because I think that we've talked a little bit about national anthem and kneeling, talked about hate speech. Campus speech, I would say we started to get to with the idea of prescribing hate speech and where you can and can't do these things with incitement. But campaign finance, just very briefly. You guys have probably heard of Citizens United?
Yeah.
So Citizens United v. FEC, what happened was there was a federal law prohibiting corporations from electioneering, from electioneering communication, and from advocating for or against a candidate. Citizens United wanted to air a video ad that was specifically against Hillary Clinton. This was prior to the Democratic primaries. They hadn't started yet, but the law prohibited electioneering communications by corporations at any time. Well, what do you think happened? Yeah, I mean, we kind of know that they were allowed to play the video. They're allowed to make these communications now. This is a really interesting case because it expanded upon all these individual rights, right? We've been talking really about individuals in all these contexts. There were some cases on corporations, but they were really couched in the idea of you have individuals in associations. What the court said, the majority, this is a 5-4 split, Justice Kennedy wrote the opinion, If the First Amendment has any force, it prohibits Congress from fining or jailing citizens or associations of citizens for simply engaging in political speech. Is that what's happening here?
Well, the court equated money and speech.
Kind of, it did. I think that, you know, and I know that's the way it's always described, like on the news and a lot of the newspapers. I don't think it directly equated money and speech. I think what it said was that as money is our access to speech through billboards, TV, radio, and all that, that it, you know, that is essential to the speech.
It amplifies
But
speech.
it amplifies speech. Previously, they had said that corporations coming together amplified it really unfairly beyond the level an individual could do. So the idea here that this is directed at what citizens are doing, I really think that overstates it. And I just have this next thing, Justice Stevens' dissenting opinion. I'd really encourage you to read that. He goes through point by point, and this was a very, very contentious case. It actually went through 2 oral arguments, and Chief Justice Roberts called it back for the second oral argument because he wanted to have a broader interpretation of the case. And that elicited a very, very strong dissent from Justice Stevens. They really aired some of the court's dirty laundry in this and talked about sort of what was behind the decision. The idea that it's not just the individuals, that the corporation has that right, that's new. And we're still kind of in flux on this. You had the Hobby Lobby case talking about a closely held corporation and the folks having their religious beliefs possibly prescribed by the government. So it's evolving right now, and I think it's going to continue to be a really hot area of law that we're going to be debating for the coming years. All right. Thank you. I want to invite Susan up very briefly to talk about as we get to Giving Tuesday. But I want to thank you all, invite you to our future events. Thank you for the folks on Facebook as well.